Welcome to Bankruptcy Through the Looking Glass with Barry Levine. I'm Sam Heninger, and I'm joined again by Barry, and we're going to dive into more things about bankruptcy, of course. Barry, thanks for coming on.
Love to be here. I'm enjoying this immensely.
Let's start off this conversation and talk about exemptions in bankruptcy. So what is an exemption and how do they vary between what we talked about previously, Chapter 7 and Chapter 13?
Well, your exemptions are the same. Be it a Chapter 7 or Chapter 13, you have to show, more so in a Chapter 13, if there are any assets available in a liquidation for your unsecured creditors, because that would be one of the bases of a Chapter 13 plan. 99% of the time there isn't. But you have the same exemptions in a Chapter 7 or a 13. In Massachusetts, you can take either the federal exemptions or the state exemptions. People who own real estate generally take the state exemptions, which almost as liberal as the federal ones, but getting back to the real estate, it allows you to take a $500,000 exemption in equity in real estate. And I mentioned, of course, it doesn't make any sense because you would think if you recorded a homestead when you were 45 and you still owned the property when you were 64, when you turned 62, the homestead would just increase to the $1 million that you're entitled to. But in Massachusetts, you have to record another homestead. And that's one of the things we do pay attention to, because I found out myself that I had to record another one. And so we make sure if they're over 62 that we record a new homestead that says they're over 62, because then, most people don't have that kind of equity, but it does protect them up to $1 million. The other protections, equity in motor vehicles. I mean, I don't know if anybody wants to listen to the numbers, but most things, unless getting back to, like I said, if you have a Picasso or something like that, most of your assets are exempt. 401ks are exempt, IRAs are exempt, annuities by and large are exempt. I mean, things that wouldn't be exempt, it would be if you had, a sizable stock holdings that, well, I was talking to somebody today and he was thinking about filing bankruptcy, and he's the best way is to tell stories about filing bankruptcy. He wanted to know what his exemption was because he had a real lot of money in his savings account or checking account. And it turns out that, when you file, if you don't own real estate and have to take the mass exemptions, federal exemption allows you to exempt anything up to about $28,000. So, most things, are exempt. The unfortunate thing is that Massachusetts, as it relates to the real estate, happens to have one of the more liberal homestead exemptions. I have a longtime client who was moved to, I don't know whether it's North or South Carolina, it's the same to me. And their homestead allows you to protect next to nothing. If you're in a bankruptcy situation, I really puts a different perspective on things, because I would think if they have the same kind of values of real estate here, which is, Massachusetts is insane right now, it could become a problem. But, on the homestead, I once represented a guy who he and his wife, they were in the process of getting separated and divorced, and they own two homes. They had a house someplace in Newton, I think, and a house down on the Cape. And the thing about the homestead is it protects a lot of equity, but you can only take one homestead, have one primary residence. We couldn't protect the house down on the Cape. I suggested that since they're separated, that why don't one of them move down to the Cape, and that's their residence, and this is your residence, and we each take the homestead. So there was equity in this house on the Cape. And for the trustee, they make money now. I mentioned they get paid $65 a case, but when they have assets that they can liquidate and bring into the estate, they make money based on a sliding scale. And then what also they do is they appoint themselves counsel to themselves as trustee, and they make money on legal fees. But in this case, what the trustee looks to do, the path of least resistance, is turning to the debtor and saying, hey, I'll sell you back your interest in the house on the Cape. I don't even remember what it was, but for X number of dollars, giving him a discount, taking care of everything. And fortunately, my client had a very wealthy father who gave him the money to pay the trustee. And that was the end of the situation. We got the settlement approved. And, it all comes down, I think I've said it's the dollars and cents. One of the stories, in the local news, they always do these stories about the supposed abuses of the bankruptcy system. And they told a story about somebody who filed a Chapter 7, and they owned I think it was at the Four Seasons, a condominium worth like $3.2 million, and they got to keep it in the bankruptcy and all this craziness. But what they didn't say is that $3.2 million condo was encumbered by an $8 million mortgage. So it's not, the example I always give, I may not look like it. I used to play basketball when I was younger. The kid who would come with the basketball and say, if you don't let me play, I'm taking my ball home.
Right.
The trustees don't do that. They're not going to sell a piece of property, just to sell it and take the guy's condo away. They're looking to make money. That's the name of the game. In most cases, most Chapter 7s are what the trustees call assetless cases. There's nothing there for the creditors. Getting back to it is what it is.
It is what it is. That's right. That's your motto, isn't it? Jeez. Let's relate this to a term that perhaps not everyone is familiar with the definition, but how would you define dischargeable debts?
Dischargeable debt is the debt that when you get your discharge, you're zeroed out. It's gone. Most credit card debt, most loans, bank loans and things like that. The only difference would be student loans. I discussed that before, but lots of folks have non-guaranteed student loans, which are dischargeable. The other thing that people and what's occurring now quite often is the SBA and its COVID largesse gave loans to a lot of businesses. Those loans are now coming home to roost. And people don't realize that while the SBA does have certain leverage to collect its money, if you don't file a bankruptcy, they could have the IRS levy your wages. I've encountered that a couple of times. Their debt is dischargeable in bankruptcy. And most potential clients are shocked to hear that. It is America. And I say that with a smile.
Now, another term that perhaps many people are unfamiliar with is this idea of automatic stays. Could you explain what that is and how they protect debtors and their actions and all?
The automatic stay actually is one of the best aspects of filing a bankruptcy. There many decades, well, it was a very long time ago, you used to have to tell people that you filed a bankruptcy. But when they changed the bankruptcy code, and this is, I think, in 1986, it became automatic. So you file, what we do, theoretically, you don't have to do anything. So if a client was having a foreclosure tomorrow and I filed their Chapter 7 today, it automatically stays their foreclosure, whether I let them know or not. But as a part of practice, we send out a notice, that tells them we filed the bankruptcy. Here's a copy of the cover sheet, and here's this, that, and the other thing, and it stops it. The same thing if you have aggressive litigation, such as filing a bankruptcy for a young lady. You sound like my father. A young lady that is having a wage garnishment threat in about 2 months in court. We file the bankruptcy before the wage garnishment, it stops it in its tracks. Again, the same thing with, and I say in 43 and a half years, the IRS has only done this once. If the IRS just happened to be selling your house and we filed the bankruptcy before the sale of the house, it stops it in the tracks. So that's what the automatic stay is. It stops any action against the property of the debtor. I think that's the language of the Section 362 of the Bankruptcy Code. It stops a creditor from taking any action against the property of the debtor or an interest of the debtor, and sometimes even against co-debtors who haven't filed. And what then happens, so now I file the bankruptcy and the automatic stay goes into effect. Then the creditor, and generally creditors involved in litigation, their debt is going to be discharged. They don't cock around with anything. They just, stop. It's more of a case where they're looking to pick up a car for non-payment, or they're looking to foreclose on a house, see something else, some other asset or collateral. So what then happens is they have to file what's called a motion for relief from stay. What that does is it asks the court to allow them to continue with their foreclosure, their seizure of the car, and even in a Chapter 11, their seizure of the corporation's assets, things along those lines. Then, as the debtor, we're given an opportunity to file an objection, a response. And, there's boilerplate. If it's a house, there's adequate protection. They're owed $500,000. The house is worth $1 million. We could not pay them for the next 6 months, and they'll still get paid. That sort of stuff. The court schedules a hearing. At the hearing, the court determines whether or not to grant them relief from the automatic stay. And, the court can allow the debtor to continue to make payments. And the court can say, hey, if the debtor has a few months in arrears on mortgage payments, give the debtor time to do it, or time to bring the mortgage current. Because by and large, the courts, the judges, they're not looking to croak. If I could turn my camera up, I'd show you the picture with all the hair. But when I first started doing this, there were people who used to game the system. Now most people who file bankruptcy, somebody, COVID, they were in the interior cleaning business, and nobody was putting people in their homes during COVID, so now they're filing bankruptcy and things along those lines. The days of, people using their credit cards to travel around, all these people, you believe these stories around the world, and, buying fancy cars, and then, for some reason, the people who file bankruptcy, somehow they can afford to pay $800 a month for a car. I don't understand it, but yet they do. But that's what the automatic stay, it sort of stops everything in its tracks. The only time it doesn't go into effect, and I don't want to take out the law book and look to refresh my memory, is if you're a serial Chapter 13 filer. So, I once represented this guy. Like I said, I didn't know him at the time. He was a high flyer. He had a 62-foot yacht. A house in Linfield that was gorgeous. He was a landscaper. And, of course, by the time he came to me, he hadn't made his mortgage payments in years, and, he was no longer a high flyer. We filed the Chapter 7 for him to stop a foreclosure. We then filed the Chapter 7 for his wife to stop the rescheduled foreclosure, or by the automatic stay. They ultimately got relief from the automatic stay. We then filed the Chapter 13 for him. And then, things we do, as long as the check clears, I filed the Chapter 13 for her. And after that, he filed several on his own. And eventually, they had a standing order in the bankruptcy court that if he filed another bankruptcy, relief from stay went into effect. The automatic stay was lifted as soon as he filed the case. And he ultimately was escorted out by the state police after he holed himself up in the house, sent his kids and wife to watch a movie. It was an interesting story. By the time unfortunately, these people get to me, sometimes I wish I represented a creditor. It would be very exciting.
Let's talk about that. I mean, creditors certainly do a lot of things, but let's narrow down and talk about what are the rights of a creditor in these situations.
The only thing a creditor can conceivably do is if they have some basis for it, is they file what's called a complaint objecting to the debtor's discharge. And there's, two bases for it. One is under, I don't want to bore you with the section, one section of the bankruptcy code that has to do with the debt itself was incurred through fraud or misrepresentation. The other section is a general non-dischargeability because the person doesn't keep records, doesn't have bank statements, and all this other stuff. The thing is, it's sort of like a Pyrrhic victory. So now, there used to be a bankruptcy court judge. He's no longer amongst the living. I think he used to say that complaints looking to object to discharge are really attempts by the creditor to collect some money, which is really what it is. So now your debt is exempted from discharge. The debtor has no money. What are you going to do with your judgment? Like I said, you could wipe your toches with it. It's not worth anything. I used to have a whole drawer with judgments you can't do anything about. Nowadays, most of the creditors, it's not like when I first started out, there were some law firms who had very aggressive collection departments. There was one guy, God bless him, who used to set exocet missiles to kill the debtors, all sorts of craziness. But nowadays, you hardly hear from any of the creditors at all, because it seems that most of them are like institutionalized creditors, like all the people who have businesses. They all think that, wow, wasn't it great? American Express gave me a $50,000 line of credit. And guess what? Your name is on that American Express card. You're personally liable for that too. And they don't realize it. Like I said, it is what it is.
Barry, we dove into some, I think, really important things this episode, and I look forward to talking more to you about this because I have so many more questions.
And if anybody happens to ask you about the posters, Fillmore West concert posters from the 1970s, early 70s, probably before your time. I only went to the Fillmore East, but they didn't have any posters available.
Well, I'm sure they mean a lot to you. I don't know what a creditor would think.
Well, all the framing is from a client I used to represent who owed me money. So, I used to have cartoons framed. It's
Bankruptcy Through the Looking Glass with Barry Levine. I'm Sam Heninger.
Take care.
Thank you so much, Barry. Don't forget to like and subscribe and stay tuned for more episodes. Welcome to Bankruptcy Through the Looking Glass with Barry Levine.